I'm sorry, folks. I'm going to start that over, my error. Hello and welcome to Western Connecticut SCORE's webinar on copyright basics and trademarks for creatives. I'm Bud Freund, the webinar coordinator and a business mentor here at Western Connecticut SCORE, and I'll be your host. Our speaker today is Cliff Ennico. More on our speaker in just a minute, but first, some brief information on SCORE. There are about 10,000 SCORE volunteers nationally in about 200 local chapters. SCORE is an SBA resource partner. Western Connecticut SCORE has about 130 mentors with a wide range of industry, process, and subject matter expertise. We offer three primary value-added services to small business owners. First, free one-on-one counseling, and we'll get to you face-to-face, telephone, email, video, any which way. And you can access that from the Request Mentor link on our website, or there should be a link on our screen as well. We do educational in-person workshops and live webinars like this, and about 100 of them per year. Also, we have extensive resources on our website, including a network of subject matter experts at your disposal. Some useful information about today's event. If you have a question, please use the chat window at any time during the presentation. It's located in the lower part of your screen. Our workshop will end at 1 p.m. to respect your time, and the session is being recorded, and the link to the recording will be available at westernconnecticut.score.org within a couple of days. Now, about our speaker. Cliff Ennico, one of America's top small business lawyers, is best known as the former host of Money Hunt, a PBS television series, and the author of Succeeding in Your Business, a nationally syndicated newspaper column. He is a frequent contributor to Entrepreneur and other small business magazines. He's hosted over 100 videos on YouTube and is the author of 17 books on entrepreneurship and career management. I'll now turn it over to Cliff. It's all yours.
Thank you, Mr. Budd, and thank you for the wonderful intro. Thanks to all of you for taking time out of your busy day to spend an hour with a lawyer, but made that crystal clear. So the audience is now just dropped in half. That's what usually happens. Have you noticed the temperature just in your room dropped by 10 degrees? Have you noticed that just now? I want you to take a quick look at this slide before we get started. This will prove that I'm a lawyer, because lawyers always tell you what we're not going to do before we tell you what we're going to do. The most important one here is the second one. We are going to be getting into some legal and tax stuff on today's program. But there's a very big difference between giving legal information and giving legal advice. Legal information is, hey, this is what the law is generally all about, which is what we're doing today. Legal advice is, now, Bud, this is what you should do, and Joe and Bill, this is why you should do it differently. That's one-on-one advice. I really can't do that in a 1-hour program. So if you do hear something on this program that sounds like a great idea and you do it and it doesn't work and your business fails, you file for bankruptcy, your spouse divorces you, the dog pees in your leg, the kids don't talk to you anymore, and you're living in a diaper box under the Brooklyn Bridge, you cannot sue anybody. Okay, that's what this basically says. All right, so let's begin. When we're talking about things like trademarks, patents, copyright, we're talking about something called intellectual property. And what does that mean? It's basically the stuff that lives inside your head. That's basically what it is. It's intangible. You can't touch it. You can't feel it. You can't smell it. But it may be one of often the most valuable assets a business has. I do a lot of buying and selling of businesses, tech companies, e-commerce companies. Nobody has brick and mortar assets anymore. They don't have plant or equipment or all the stuff that I learned about in my high school accounting class 50 some odd years ago. It's all intellectual property, and valuing it, can be something of a challenge. But when we're talking about patents, trademarks, and copyrights, we're talking about ways that you can protect your intellectual property against copycats and other evil people. And there are three ways that you can protect your intellectual property. And then there's patents, trademarks, and copyrights. The thing you need to know about these things have nothing to do with ownership. I talk to people all the time who think, well, if I have a patent on something, I own it. I have ownership rights. That's not legally Correct. That's not accurate. What these things are legal monopolies. Now, if you know anything about our economic system, we're a capitalist economic system. We do not like monopolies in general. Monopolies are bad things. If a company has a monopoly in a certain product or service, it means they can charge whatever the hell they want, and they can basically screw over the consumer in ways. These are nothing. That's why we have a whole body of law called antitrust law designed to prevent monopolies from happening. But these are three situations in which a monopoly is a good thing. The government is giving you a monopoly for a period of time to basically say that for a period of time, only you have the right to capitalize on this thing, whatever it is, and nobody else can mess with you, at least for this period of time. Patents have to do with inventions and sometimes designs. If you're Thomas Edison or Elon Musk, your latest your latest innovation of the electric vehicle engine is something you would patent. Trademarks have to do with names, brand names, and other marks that you put on your products and services and that are visible to the consumer in the stream of commerce. We'll talk more about those in a minute. Copyright has to do with arrangements of words in the English language, literary works, slogans, things like that. What you cannot protect are ideas. Ideas are not protectable in the United States. So for example, if I want to write a book about a young boy who discovers he's a wizard and he goes flying off to wizarding school and learns all this crazy stuff, as long as I don't use the same names and the same basic plot lines of the Harry Potter books, I'm free to write anything I want. The idea of a book about a boy wizard is not something that can be copyrighted, although each one of J.K. Rowling's Harry Potter books, of course, are copyrighted. Okay, so that's the basic difference between these things. We're not going to talk about patents today. Today's program is strictly about trademarks and copyrights. Let's talk for a second about the differences between these two things. Okay, let's start with copyright first. Copyright has to do with literary works, books, poems, anything in the English language or in any language, frankly, that is an arrangement of words. That is basically what you copyright. Slogans are arrangement of words. Marketing copy and graphics, other than logos. So for example, haiku poems. Good to the last drop, which is a slogan for Maxwell House Coffee. Trademarks are different. Trademarks are marked. You don't trademark names, you trademark marks. Now, a mark can be a word, okay, but it doesn't have to be. It can be a graphic, it can be a logo. Maxwell House Coffee is a trademark. The Pillsbury Doughboy, that little fat bastard, he is with the stupid hat. He is a trademark. The McDonald's Golden Arches are a trademark. It can be a company name, but it has to be used on products or services. When I go to the grocery store and I pick up a box of Ronzoni pasta, I'm Italian American, I eat a lot of that stuff. Ronzoni is certainly a trademark of the company that owns Ronzoni, but the company name does not appear on the box. Okay, so that's an important thing to recommend. When you trademark something, you're not trademarking a name or a company name. You're trademarking what actually appears on the products or services that the consumer actually sees. Copyright is slogans and things like that. So Maxwell House is a trademark. Good to the last drop is a copyright. Okay, and hopefully that's a little bit clearer. Anyway, so let's begin with copyrights. We'll talk about copyrights. I've written 17 books, so I kind of know a little bit about copyright law. I couldn't afford to hire an attorney years ago when I wrote my first book, so I had to negotiate all my publishing contracts myself. And when you do that, you learn a lot about copyright. That's for certain. Okay, so here's what we're going to begin with a little bit of an exercise. Okay, we're going to be a little California today. This is going to be a little bit of a Zen exercise. I want you all to close your eyes just momentarily, and I want you to picture a table in a room with a light over it. Okay, and on this table is sitting the Mona Lisa, the original Mona Lisa that Leonardo da Vinci painted back in the 1400s sometimes, okay? We borrowed it from the Louvre specifically for today's program. Okay, and it's the actual thing. Okay, you're looking at it. Now I want you to picture about 2 or 3 feet above the painting. I want you to picture a hologram that looks exactly like the Mona Lisa, down to the very last brushstroke, but that's intangible. It's a hologram. You can stick your hand through it. It's not something you can touch or feel or smell or taste. Not that you want to taste the Mona Lisa, but anyway, it's a hologram. Okay. Now I want you to visualize that. So this hologram is hovering in the air a couple of feet above the painting. And now, last but not least, before you open your eyes, I want you to visualize removing the painting, taking the painting off the table, but leaving the hologram in place, floating in midair. Okay, great. You can now open your eyes, by the way. If this were a live program, I'd have to wake some of you up. Hopefully I don't have to do that on the webinar. I like that little visual exercise because it illustrates perfectly what a copyright is. When you create something, a work of art, a literary work, a painting, a sculpture, something like that, you don't just create the physical object that's sitting on the table, but you also create something called a copyright, which is an intangible hologram, if you will, that looks exactly like the thing that you have just created, but that is not intangible and that sits floating in space. And that thing, that copyright, moves independently of the work of art that you yourself have created. That's the purpose of that little visualization exercise, is to give you sort of a visual. I tend to think visually. I like to see pictures of things, and that's my picture of what a copyright looks like. Okay, a copyright has nothing to do with ownership. It's a legal monopoly. It's the legal right to exclude others from profiting from a creative work for a period of time. There are different periods of time depending on what the work is. It literally is the right to make copies. Copyright is the right to make copies and duplicate and publish the work. It contains a bundle of rights which change over time. Okay, what does copyright give you? It gives you the exclusive right to publish and make copies of the work, the exclusive right to profit from the work and any derivative works. We're going to spend some time talking about derivative works later on. The exclusive right to edit, alter, or change the work, and the exclusive right to sue others who infringe your copyright and make them pay through the nose. So if you create a painting, let's say you create an authentic work of art, and let's say you send it to a gallery, they sell it, you get paid for it, you have sold the painting. The buyer can take that painting and do whatever they want with it. They can hang it on their wall, they can destroy it if they want to. It's silly to do that, but they could do that. The one thing that they cannot do, though, is they cannot change it or make copies of it. That's where the copyright comes in. When you sell a painting in an art gallery, you have not sold the copyright to that painting. You still retain the copyright to that painting and the rights that go with that. There are plenty of copyrights out there for works of art that were destroyed by the Nazis during World War II, but the copyrights are still valid for those paintings, even though the actual physical work of art no longer exists. The copyright moves independently of the work of art to which it is initially attached. Okay, so what are some of the things you can copyright? Well, basically any arrangement of words can be done. Any work of art, paintings, sculptures, architecture, certain types of building. The Chrysler Building in New York is actually a copyrighted work. Original content is always protected. So your website, for example, your website text on your website. You go to cliffennico.com, my website, you see I got this stuff. I'm talking to you about all the stuff that I do. That text is copyrighted material. Okay, no one else can copy that without my consent. Oh, Lord knows people do it all the time. Anyway, your domain name, no. Your cliffennico.com, you protect the domain name by registering it as a trademark. Okay, or by registering it with a domain name registrar. Cliffennico.com means nobody else on the internet can be cliffennico.com. They may be cliffennico.net, .org, .biz, .info, but they cannot be cliffennico.com. If you're looking to build a brand out of your website, you should get a federal trademark on it. Your recipe for baked beans, no. If it is a mere listing of ingredients, that is not copyrightable. Yes, if it's accompanied by substantial literary expression in the form of an explanation or directions. That's why if you ever get a cookbook, a gourmet cookbook, they don't just give you the ingredients and the proportions and stuff. They actually have this little essay about how you do it, how you put it together, how the author of the book discovered this in a little village in Tuscany. That's why they do that, so that they can copyright the recipe, which otherwise would not be copyrightable. Your company name? No. For company names, you have to get a trademark for it if it's trademarkable. We'll talk about that later. Directories are databases of information. You cannot copyright the phone directory. Directories and databases get very complicated. You really need to talk to a lawyer about that. There's some very specific law and specific case law governing directories and databases. Sometimes you can copyright them, sometimes you can't. When does copyright attach? At the moment of creation. A lot of people don't realize this. When you create a poem or an article or a book or any kind of work of art, literary work, the copyright attaches at the moment of creation. You are not legally required to register your copyright. So why do we have the copyright? Why does the Copyright Office allow you to register your copyright if it's not legally necessary? The answer is because when you create a work of art, you have to show the date upon, you have to be able to prove in court the date on which it's created. If you create a work of art and you see something online that is ripping you off, you have to go to court and basically show that that you had created this work of art prior to the date that thing was posted up on the internet. And that's why you register your copyright. If you register your copyright and you get the TXU stamp from the Copyright Office, that is proof and irrefutable proof that at that moment in time, your work existed and was absolutely created. Okay. And when you have a copyright now, you don't have to register it, though. But you don't have to register it, but you do have to have a way of proving when you created the work of art. So, for example, you always include the statutory copyright notice on each work or individual page. So take a look at the bottom of the slide. There's the statutory copyright notice. It's either the letter C in a circle or the word copyright. You can write it out either way. 2026 by Clifford R. Ennico, all rights reserved. Now look at the bottom where it says 2015 to 2026. What that says is that I created this set of slides in 2015, and I have been updating and changing them every year ever since. So I'm claiming a copyright for each of those 12 years. Okay, that I've been using this for SCORE presentations and other presentations elsewhere. Let's say that you don't want to register your copyright. Sometimes it's a bad idea. So let's say, for example, you do have a hot literary property and you register your copyright. Okay, the good news is now you have proof that that work existed, but you've also published that work on the copyright register, and anybody in the world can look at that and see what it is that you did. And there are people out there, we call them copyright trolls. There are a lot of them in China, not that particular country, but it tends to be very popular there, who do nothing but search the copyright records looking for things that they can steal. So why do you want to lead with your chin like that and put it on the copyright? So there is something you can do, especially with literary works. It used to be called poor man's copyright. We call it poor person's copyright now. We take the sexist language out of it. But basically what people used to do in the old days when they used to write a book, what they would do is they'd go to a place that has a copy machine. They'd make like 3 or 4 copies of it. And what they would do then is they would mail the manuscript to themselves, is what they did. Okay, why? Why do they put this in an envelope and then mail it to themselves? The answer is you want the postmark. When the package arrives in the mail, it has a postmark on it, and that postmark is proof that at that time that work existed. Now, of course, when you do this, you cannot take the manuscript out of the envelope. You keep it in the envelope if, in case, God forbid, you ever get sued. But that envelope, that sealed envelope with the postmark, would be proof that that manuscript existed at that moment in time. People used to do this all the time in the days before computers in the early 1980s. I did it myself with the first couple of books that I wrote when I was a student in college and stuff. This is what I used to do. And it's still a very valid way of doing things, but you have to have some way of showing when you created the work that is well. Obviously, if you're creating an artwork or a sculpture, put it in a sealed envelope and mail it to yourself. It'll probably get crushed. Probably, and also too, if it's the only existing copy, you can't keep it in the envelope. So keep it in mind. This doesn't work for everything, but it does work very well for books and other literary works. Okay, how do you register your copyright? This is basically what you have to do. You have to file the correct, there are different application forms for different types of copyrighted works. A non-returnable copy of the work in paper or audio recording. The Copyright Office currently does not accept digital submissions, except for photographs. They do submit for that, but only for photographs. Anything else has to be in paper or audio recording for it's a work of music, for example. There's a filing fee. You can file electronically. You can register up to 10 unpublished works. The Copyright Office is now allowing you to group these things and file in bulk. In fact, if you're a photographer, you should be aware that you can register up to 750 unpublished photographs for a single fee. And you definitely want to look at that. The Copyright Office, by the way, publishes circulars on everything that they do. And those Copyright Office circulars are probably the best thing in print on how to copyright anything that you're looking for. They have different circulars for different types of copyrightable works, and they're written in plain English. You don't have to be a lawyer to understand these things, and they're free. By the way, they're free downloads from the Copyright Office website at copyright.gov, not copyright.com. It's copyright.gov is the website for the Copyright Office. Don't go to copyright.com. There are people doing all kinds of crazy things there that you don't want to know about. It's copyright.gov that gets you to the Copyright Office. Who owns the copyright? Well, the answer is it's you, the author or creator. The minute you create this work of art, whatever it is, you automatically own the copyright. You do not have to register it with anybody. You don't have to show it to anybody. You are as the author, you own the copyright. The copyright has attached at that exact moment. You can pass your copyright by will when you die. And even if you're a minor, by the way. Even if you're 15 years old and you're very talented and you create a work of art, you're a musician or something, you write a rock song or something like that, like these people that are on America's Got Talent, some of them aren't even of legal age. Although you cannot be legally able to sell or license the copyright without parental permission, but the fact is you can still own the copyright even though you are a minor. If you created your work as part of your job, if you are a W-2 employee of a company and you created this thing as part of your job description, then your employer owns the right to what you did. That's called the work for hire doctrine, or the work made for hire doctrine. We'll talk about that in the next couple of slides. Not the owner of the physical object. If I buy a painting at an art auction, I certainly have the right to do whatever I want with the actual physical object that I bought, but I do not have the right to make lithographs, seriographs, or anything like that. And also, very importantly, not your client if you are an independent contractor. If you create a work of art for somebody else, and they pay you, and you're an employee, then they own it. They own that painting or whatever it is you did. But if you are acting as an independent contractor, as a 1099, and you create something for your client, the client does not own your copyright. They own the thing that you gave them, but if they paid you for it, but they don't own the copyright to it. You can still make copies of that for other people. That's why whenever you hire somebody as an independent contractor to create something for you, you always want to make sure that they assign their copyright to you so that they don't do that. So they don't go and sell this thing that they created for a gazillion other people. How long does a copyright last? There are some pretty complicated rules here, but I'll summarize the basic ones. Copyright only lasts for a period of years. It's not forever. After that, the work goes into public domain, and anyone can publish that work without obligation. Now, let me be very clear about this. There's a lot of confusion about what public domain is. The Adventures of Huckleberry Finn by Mark Twain is in the public domain. Okay, that does not mean that I can go out there, take that book, and republish it as The Adventures of Huckleberry Finn by Cliff Ennico. That does not give me the right to do that. That would be theft of intellectual property if I did that from Mark Twain's estate. Okay, that would mean I could easily go to jail for that if I ever did that. What it doesn't say, though, is I can publish my own edition of The Adventures of Huckleberry Finn by Mark Twain. I can take that text and publish that work without having to pay royalties to Mark Twain's estate, as long as I don't make any changes to it. Okay, that is what public domain. Public domain is like open source software. It's the same concept. Anybody can publish this work, but they don't have the right to steal the work and claim it as their own, because that would still be considered theft of intellectual property, even though the copyright has technically expired. For works created after January 1, 1978, copyright protection lasts for the life of the author plus an additional 70 years. This is for books. So that means that if I were to drop dead today, my spouse and my estate would be able to get copyright royalties on all of my books and articles and everything that I've written during my lifetime until 2096, which is a long time away. I mean, by that point we'll have discovered the Vulcans and the Klingons, and we'll be living in the Star Trek universe. For an anonymous work or a pseudonymous work or a work made for hire, the copyright endures for 95 years or 125 years from the year of its creation, whichever expires first. For works published prior to January 1, 1978, you have to look at the copyright law in effect when the work was first published. And here are a bunch of websites that can help you figure out when a work was initially copyrighted or first published. These are some lines. Watch out for translations and subsequent editions. Now, those of you who went to college, and especially if you took courses in the sciences, you know that every year the publisher came out with a new edition of your textbook, and it drove you crazy because you couldn't just buy last year's edition from a buddy for $2. You had to go out and buy this year's. Now, I will share a secret with you. Those two editions were almost exactly identical. The author just added maybe a few words, a couple of paragraphs, and the publisher came out as a new edition. But each new edition of a work technically starts a new copyright period going. And that's for subsequent editions. So for example, that's one of the reasons why with these PowerPoints that I do for SCORE, every year I update them because it adds another year to the copyright period. Okay. How do you profit from copyright? Okay, basically you can either sell or license your copyright. Sales of copyright are sometimes called assignments. Selling or assigning a copyright is virtually the same thing. Okay, selling a copyright means you no longer own it. You have given up your copyright. You have not only sold the painting, you also sold the hologram as well. You no longer own it. If you do write a book, and if you're lucky enough to have it published by HarperCollins, as one of my books is, your publisher will definitely want an assignment of copyright. They are taking the risk of making copies and putting these in bookstores around the country, Barnes and Noble. So they're taking the risk, and they definitely want the copyright. They want the right to be able to make copies and do whatever needs to be done in order to generate sales. You will not be able to get out of that or negotiate your way out of that. But I always I have written books for publishers that were not HarperCollins, that were small mom and pop publishers where I didn't know if they were going to be around next year. I always try in my publishing agreements to put a clause in the agreement that says that my copyright reverts to me if the work is no longer in print or sales fall below X units per year. If the publisher is not doing their job, I don't want them owning the copyright for 75 years. I don't want that. I want to get the copyright back so I can find a better publisher. Maybe rewrite it, update it. I'm doing that right now, actually, with one of my books. I acquired the copyright back from the publisher because they wouldn't let me do a new edition, which I need to do because the laws have changed. So I'm doing that right now for another publisher. I always make sure to include that clause in any publishing agreement where I'm assigning my copyright. I don't want to assign my copyright in perpetuity. If things aren't working out with this publisher, I want to get it back at some point. Be careful when posting on social media. I think all of the social media sites, such as Facebook, Meta, LinkedIn, they basically have a thing in their users agreement or privacy policy that requires you to assign copyrights to all your postings that you're posting online. So if you post a picture of, say, a photograph to Facebook, I'm still going to call it Facebook. I know it's called Meta now, but I'm going to call it Facebook. That's what everybody still calls it. If I post a photograph and the people at Facebook in California really like it, they could, in theory, take that photograph and publish it all kinds of places, and reproduce it in all kinds of places without my consent. Now, they don't actually do that. What they really want is the kind of thing where if they see something they really like, they can put it up on a thing like, hey, here are the 100 coolest postings on Facebook today, and there's yours along with everybody else. They want the right to be able to do that. They're not really evil people, at least most of them aren't. But I do think you have to be careful. That's why I always tell my artists and photography clients, whenever you put stuff on social media, don't put it up on Facebook. Put it on your website. So that way it's under your user's agreement and terms of service, not Facebook's. You can certainly put something on Facebook saying, hey, I've got some cool new photos. Check out my website. Check my website. It's such and such URL. to look at them, but don't put the actual photographs and stuff up on Facebook because then you're under their terms of service and you technically have assigned your copyright to them. Work made for hire, we talked about this earlier. If the work was created in the course of someone's W-2 employment, the employer automatically owns copyright from the work, but this is not so for independent contractors. A little piece of Supreme Court history, the Reed case, which was a Supreme Court case from 1989, it was the last case decided by Thurgood Marshall before he retired from the court. Reed was a sculptor. He basically created a bronze sculpture of a homeless family for an organization in Washington, D.C. that was created to help the homeless. They were going to put this basically in the lobby of their building in Washington. Well, Reed was a very advanced sculptor. He was very avant-garde, and he created this very abstract sculpture. It was not very popular. People didn't like it. They thought it was ugly. Now that the organization had paid him for it. They paid him for the sculpture. He got full payment for the sculptor, but it was so unpopular that they went back to him a year later and say, you know what, Mr. Reed, this is just, can you please soften this a little bit? Can you make a few changes so it's a little bit, people are saying this thing is ugly, and that's not the image that we really want to have for our organization. And Reed was an artist, true artist. He came back and said, no, I'm not doing that. This was my vision. This is how I envisioned this. I'm not making any changes to it. And the organization said, well, that's okay. We paid him for this. So that means we own this thing. We can do whatever we want with it. So they hired another sculptor to come in and make changes. Reed sued for copyright infringement, and it went all the way to the Supreme Court, and the court decided with Reed. The court said that because he was an independent contractor, not an employee of the organization could not change his creation without his consent, even though he had been paid for it. So this is something to keep in mind when you're dealing with independent contractors. If you're in the creative business and you hire student interns, for example, to create, help working on your stuff, they're minors, but keep in mind, minors can still own copyright to things. You got to get them to actually sell their copyright to you, or else they can basically take whatever they've done and they can use it any way they want. And that's because of the Reed case. A derivative work is a work that is based on a copyrighted work that is based on another copyrighted work. So, for example, the author of a Broadway play that's made into a movie has the copyright on the screenplay automatically, and they get rights on that. That's where authors of theater works get rich. If they don't get rich on Broadway, they get rich when their work is made into a movie, and they get a piece of the movie rights. But the law also protects parody, and this is automatic, by the way. If I write a book and someone makes a movie out of it, I automatically own the copyright in the screenplay of the movie. Even though the studio has not asked my permission, I still own it. But the law protects parodies of copyrighted works, which can be copyrighted in their own right. And this is a very complicated area of copyright law. Back in the early 2000s, a lady wrote a book called The Wind Done Gone. It was basically the Gone with the Wind story as told from the perspective of a slave on the Tara plantation. It was a book that was written from the perspective of an African-American slave on the Tara plantation. Now, the same characters were there, but the author was very, very careful not to include specific scenes from the Gone with the Wind book. This was a totally new story with an entirely different plot line. It involved the same characters, Rhett Butler, Scarlett O'Hara, but it was written from an entirely different perspective. And the Second Circuit in New York basically said Margaret Mitchell's estate sued the author and the publisher of the book. The court sided with the author, saying that the work was sufficiently different from the original work. It was transformative, and so it was not a derivative work of the original Gone with the Wind book. Now, that's one case. In the same year, a Swedish author wrote a book. Those of you who suffered through high school English classes, at some point you read the book called Catcher in the Rye by J.D. Salinger, and you heard about what's the character's name in that book? I can't remember his name, but he's just one of the most. I hated that book. Holden Caulfield. Holden Caulfield to me was just a whining loser at all. I never cared for him. I didn't care for the book. I hated that book when I had to read it in high school. Okay. Well, a Swedish author, apparently the book does have some fans. It's considered a classic. A Swedish author decided to write a book about what happened to Holden Caulfield when he grew up and is now a 60-something baby boom geezer. And he did refer back to a lot of scenes in the original book. He used some of Holden Caulfield's trademark phrases like somebody being a phony and all that stuff. And the Second Circuit, the same court that had upheld the Win Done Gone, ruled against him, actually ruled. The estate of J.D. Salinger sued this guy, and the court sided with Salinger's estate. And not only did they collect royalties from this, they also suppressed the publication of the book. Now, here's one of the most liberal courts in the United States, the Second Circuit, that sits in Manhattan, one of the most liberal courts in the world, enjoining the publication of a book because it violated the original author's copyright, as it was considered a derivative work of the original work. And J.D. Salinger estate did not want royalties. They wanted this book to be shut down. They didn't want it published. And the court went along with that. So these are two cases from the same court in the same year that give you some sense of how complicated this can be. To avoid being classified as a derivative work, the work must be transformative, able to stand on. And that analysis is very fact specific. No two cases go the same way. Okay, some of the trickiest cases in the copyright law books are cases involving transformativeness of whether or not a work is sufficiently transformative that it's not considered a derivative work of another. Okay, last on copyright, we're going to talk about fair use. Can other people use your copyright work without your permission? Short answer, no, unless you let them, unless you give them permission. Can you use other people's copyrighted works without their permission? Short answer, no, unless they give you permission. Right? Simple, right? So why is it that I've got 3 books 6 inches thick on my bookshelf on fair use cases? Why is there so much litigation in the area of fair use? Okay, as long as you give due credit, it is permissible to use limited portions of a work, including quotes, for purposes such as commentary, criticism, news reporting, and scholarly reports. This is the rule that got you through college. You know yourself, when you wrote college term papers in college, you plagiarized like hell. You did, but you just put everything in a footnote, and so it was okay. You were not committing copyright infringement. Some people think that there's a rule out there that says that if you do a specific number of words or musical notes or percentage of a work, that you're okay. And I should tell you that there is no such thing. The courts have decided over and over again, there's no such thing as a certain number of words or notes that will put you on either side of the fair use of a fair use case. They will not. Whether or not you use the other person's material properly depends on all the facts and circumstances. But here's something for those of you, who are math geeks, by the way. Here's some interesting math. The odds that 2 people acting independently and without knowledge of each other will write the same paragraph with the exact same words in the exact same order is 1 divided by 1 quadrillion. 1 quadrillion, more than 2 to the 50th power. Okay, try to do this on a calculator. You cannot do it on a calculator. Basically, the odds that 2 people will write the same paragraph with the same 50 words in the same order is basically 0. So if you're looking at something online and you see that 50 words or more are exactly the same as something in a book, that's copyright infringement. There's no way that could have happened mathematically. That could have happened. That could have happened in the real world. So how do you find the copywriter? You want to use somebody else's stuff. You're not sure if it's fair use or not. So you got to find the copyright owner and get permission. I get these requests all the time. Every week, I get an email from someone, usually it's a professor, that wants to use one of my articles in a case book that he's putting together for his students. I always say yes to that because it's how I market myself. It's how I get my name out there. As long as it keeps my name on it, I don't really care. I don't need the few pennies that will pay me as a royalty. But how do you find the author of the work? I mean, the U.S. Copyright Office will help you for a fee, about $20, $30. They will do this. Basically, this is what they do with their summer interns, their college interns. They put them to work helping people find the authors and who they are. There are collective licensing agencies out there for a lot of like older books and things like that and works of art. There are permissions editors. These are usually retired editors from publishing companies that basically, for a small fee, will do some research and help you track down. When all else fails, you should hire a copyright lawyer if you really can't find who owns the rights. And it can be tricky. Just because a work is old does not mean that you can just take it and use it without permission of somebody. Usually the estate of the author has something to say about it. Sometimes it's owned by somebody else. It's really crazy. Those of you who know, if you're a Beatles fan, the copyright to some of their early songs, the songs from the Beatlemania area, nobody really knows who owns the rights to these things, right? Because the original manager, Brian Epstein, he was a great human being. He wasn't a very good manager, and he allowed these copyrights to get out of hand, and they ended up all over the place. Okay, let's talk about trademarks right now. Okay, a trademark is a legal monopoly on marks, not necessarily names. The first question that I get sometimes from a client that wants to start a new business is, I want to trademark my company name. Well, you can't trademark your company name. What you trademark are marks that appear on the product packages. I actually ran afoul of this. Back in the 90s, I had a small company called Bienix Corporation. It was a self-publishing firm. We were doing books for lawyers to help them with their career management. We did career information for young lawyers, people who were just out of law school and didn't know whether they wanted to work for a law firm or a government agency or that kind of thing. We were a career information resource for lawyers and other legal professionals is what we were. And I tried to trademark the name Bienix with the trademark office. I tried doing it myself. The trademark office bounced my application, not because the name wasn't trademarkable, it clearly was, but because I sent them some sample book covers and I wasn't using the name Bienix on any of the book covers. I was using the letter B, a stylized, font in a stylized font. I wasn't easy. They sent me a nice letter saying, hey, send us back some book covers with the name Bienix on the cover and we'll let you trademark the name Bienix. The issue wasn't trademarkability. The issue was that I wasn't actually using it in commerce. And that's something you have to know. You must be used in commerce or you lose it. Okay. If you plan on branding your business, if you're doing a business where the value is in the brand, the name, you need a registered trademark. End of story. Okay. Whenever I hear a client saying, I'm going to be building and doing this kind of service, whatever, and I want to be able to brand it, the minute I hear a lawyer hears the word branding, the words registered trademark pop up in my head. You absolutely have to have that. A brand name is no good if somebody somewhere else in the country can rip it off legally and get away with it. You do not want that. Technically, a trademark is for products, service marks are for services, but nobody really distinguishes between those two things. Okay. Now, have you ever seen anything, a package or something where the little letters TM or SM appear after the name? What this is what we call a common law trademark. Okay. A registered trademark is the R in a circle, the letter R in a circle. But whenever you see a TM or an SM, it means that this is not registered with the trademark office. You do not need to register your trademark with the trademark office. In fact, sometimes you can't register your trademark with the trademark office for reasons I'll explain in a minute. When you're putting these letters next to a name, you're saying, I'm claiming this is a trademark. I don't know if I can trademark it or not, but I'm claiming this is a trademark. And if I see you using this mark for the same or similar product or service, I will sue your ass off. That's what you're doing when you put the TM or SM next to a name. Now, it's not as powerful as copyright is. You can definitely sue somebody for infringement, but if the other person can prove that they were using it before you lose. There was a case about 20 years ago involving McDonald's, the restaurant chain. McDonald's went after this small family-owned restaurant called McDonald's Family Hamburgers in Southern Illinois that had been operating since the 1930s. Now, McDonald's wasn't incorporated until sometime in the 1950s, okay? The case went all the way to the Seventh Circuit in Chicago, and they decided, basically, they ruled in favor of the little guy. They ruled in favor of the family restaurant, saying that, yes, McDonald's has a very valid trademark on the name McDonald's for hamburger restaurants, but this outfit was operating at least 20 years before they were even incorporated. So they were allowed to continue using the name McDonald's. What they ended up doing, by the way, McDonald's actually bought them out eventually and turned them into a franchise, is what they did. They made them an offer they couldn't refuse, which is probably how it should have happened anyway. This thing should have never gone to court. But whenever you are trademarking, it's a name that you're not really sure about. It's a good idea to do a very thorough trademark search and make sure that there's nobody else out there already using it for the same product and service. Because if they are, and if it's a common law trademark, they will win. You will not win. If it's a registered trademark, you win, even if they have been using it prior to you are. Okay, the trademark is identified by the R in a circle, must be registered with the trademark office. It is a federal crime, a misdemeanor, to use the R in a circle if the trademark is not registered. Okay, you can sue others for infringement if they, serve seeing the mark for the same similar products. Domain names are trademarkable. Okay, so cliffennico.com can be trademarked. Although that's not a matter of trademark law, that's a matter of internet law. The minute you register your domain name with a domain name registrar, nobody else can use that same, but they can use a different suffix. They can be cliffennico.net, .org, .biz, .info, .cliffennico, whatever. I mean, that's why when you register a domain name, you always try to claim as many of the most common suffixes as possible so that nobody else can get them. Okay, even with a registered trademark, you can still be sued for infringement. If they can prove that they were using your trademark first, in particular, then they will be allowed to continue using. They cannot take your trademark away from you, but the court will almost certainly let them use the trademark in that particular area, as the Seventh Circuit did with the McDonald's family restaurant in Illinois. If that ever becomes an issue, my advice to clients is to stay out of court and to try to negotiate. It's something you can do called a coexistence agreement with the other trademark owner, saying, well, as long as you stay within this product category and I stay within this product category, we won't have a problem with this. The or dual license. I mean, that's ultimately, what happened in the McDonald's case is that McDonald's basically got a long-term license from the restaurant owners in Illinois, and they actually ended up buying them, over time when the family patriarch died. I mean, that's basically what happened there. How long does a trademark last? Initially 10 years after registration, and it must be renewed every 10 years. You can renew indefinitely, and here's the big difference between trademarks and copyrights. Copyright is automatic. The minute you create a work and it's copyrighted, you own that copyright for 75, life of the author plus 75 years. You do not have to, file anything anywhere to get that. It's a matter of law that you get that. Trademarks are different. You have to register them, but if you stop using it in commerce, you lose it. A trademark is only good for as long as you are actively using it in commerce. That's why there's a lot of litigation now about trademarks that have not been used. They're still valid. They're still registered with the trademark office, but for products and services that no longer exist. And the question arises there, is the trademark still valid? Because it's not actually being used on a product or a service that you can buy in your local stores. There's a lot of litigation about that right now. I actually had a client a couple of years ago that was trying to go around buying expired trademarks because he wanted to resell them and repackage them for people who are fond of antiques. He wanted to do reproductions of old advertising signs for products that no longer exist, that kind of thing. He wanted to do, and there's some big issues about who still, even though the product or service is no longer being sold anywhere, sometimes the trademarks are still valid and they're still owned by people that are a lot bigger than you are. So you have to cut a deal with them. Whenever you have a trademark, you have to defend it against infringers. If you see somebody out there who's infringing your trademark, you have to send them a letter. It's called a cease and desist letter, ordering them to cease and desist use of their trademark. I do these for my clients all the time, even though I'm not really a trademark specialist, but I do this all the time because you have to. It is required. If you don't enforce it, if you allow other people to use your trademark, then you lose it yourself. The other way you can lose a trademark is to allow it to become generic. Escalator, aspirin, Kleenex, these were at one time registered trademarks of major corporations. No longer anymore. When you blow your nose into a soft tissue, you're blowing it into a Kleenex, even though the product, the tissue is being manufactured by another company, but not Google. By the way, you can certainly use the term to Google something, but don't try to make money off it. There was a case in 2014 that basically Google won that one. They paid a ton of money. You cannot use the word Google as a generic term, although hell knows we all do. Okay, so here's some of the steps to trademarking a name. First of all, the first question you have to ask, is the name trademarkable? Not every name is trademarkable. The name cannot be generic, descriptive, geographical, a surname. Interestingly enough, think about Joe's Garage. Okay, this is the thing. Trademark are specific to product categories. Even though someone has a registered trademark for a certain category, you can get a trademark for another category. So, for example, if my name is Joe and I have a garage somewhere, I cannot trademark the name Joe's Garage because it's considered, descriptive. of what I do. But somebody actually does own the trademark for Joe's Garage. And the answer is the estate of Frank Zappa, the musicians. One of his albums was called Joe's Garage, and he has the trademark for Joe's Garage for music recordings, not for anything automotive, but for music recordings. That can be done. Okay. Anything that is immoral or offensive or scandalous. Back in the 90s, a brewery in Michigan came out with a craft brewery called Bad Frog Beer, and its logo was a frog sitting on his lily pad, and his webbed foot was reaching out with a certain digit extended. Okay, you can picture this in your mind. Basically, the slogan was "Bad Frog, he don't give a damn." That was it. And it was hysterical. And by the way, you can still get the beer, you can still get 6 packs of the beer on eBay for about $35, by the way, if you're really into this. There are people who collect, advertising, offensive advertising. There are people who do that. There was a marijuana dispensary in New York a couple of years ago that had a slogan, "You can't spell healthcare without THC." Don't get too cute with this, okay? Because the trademark office will refuse to register your trademark if they find it immoral or offensive. Anything that's deceptive or false, like lawyers do this all the time. We're the winningest lawyers in Missouri. Lawyers are the biggest offenders here. You can't make false or deceptive statements like that or disparaging another person. You also cannot use the likeness of a living person without their consent. The law gets a little bit more complicated when you're talking about dead people. So, for example, if you go to a liquor store, any liquor store here in Connecticut, you'll see a bottle of wine that's made by a winery in California called Marilyn Merlot. And it's got a picture of Marilyn Monroe on there. Now, they have the license from her estate to do that. So it's perfectly okay for them. But when it comes to dead people, there are some very specific rules about when you can and can't, use their image. A trade name may be trademarkable if it's successful, effective, arbitrary, fanciful. Here's my rule. Whenever you're looking to name a product or service, the less your name has to do with the product or service, the better. What does Monster have to do with looking for books online? Looking for jobs online? What does Penguin have to do with books? What does Camel have to do with cigarettes? Camels don't smoke cigarettes. I mean, come up with a name that has nothing to do, and it's much more likely that it will be trademarkable and it'll sail through the trademark application process. Step number 2, you have to ask, has someone else trademarked the name? A name cannot be trademarked if it is confusingly similar to another registered trademark. I always tell my clients, hire a trademark law specialist and do a very, very thorough trademark search to make sure that there's absolutely nobody out there with a registered trademark. I cannot tell you how many times, and it's heartbreaking. I have a client that doesn't have a lot of money. They start something up. Usually it's a publication of some kind. They don't trademark the name of it. They don't trademark the brand name or whatever. And they actually gain traction. They get investors. And then all of a sudden they get a nasty cease and desist letter from some law firm in Washington State saying, cease and desist. We've had this trademark for a similar publication for 50 years. You can't do this anymore. These people have raised money. These people are out there. They're getting customers. And now they have to change their whole brand image overnight to avoid a lawsuit. That's a heartbreak. And it's a situation you never, ever want to find yourself in. Whenever you're starting a business, and especially if the name is important, if it's a brand name that you're relying on, get the federal trademark and do not do anything until you get that. Okay, don't do it yourself. You can either hire a trademark attorney. The cost will be somewhere between $1,000 or $3,000. It's not that expensive. Or there are trademark services out there. LegalZoom, the company that forms corporations and LLCs, also has a service where they will register your trademark. It's a lot less expensive, somewhere between $50 and $250. The thing you have to know, though, about the online, and there are other online services that do it, but the thing you have to know about the online services is that if they file with the trademark office and the trademark rejects it or questions it, they will not defend that. They're going to tell you to go get a lawyer at that point. They do not fight battles with the trademark office. If the application sails through, they'll make sure that it goes through properly. Okay, so my advice is if you want to try to save money on the trademark filing, do a little research and make sure that the name is absolutely clean and that there's not going to be any problems. If there's even a slightest suspicion that you might be similar too close to another registered trademark or that the name might be trademarkable, get an attorney. Do not use one of the online services because the attorney is obligated by law to help you fight this battle with the trademark office. They'll help you respond to the trademark office. They'll sometimes even go down to Washington and meet with the trademark examiner to help solve this problem. The online services will not do that. Okay, if your name cannot be trademarked, if it's impossible to do, well, maybe no one else can either. That's when you have to consider using a common law trademark, the TM or the SM. Basically, what you do here, see if anyone else is using the name, and then if there's nobody else out there, market the hell out of your name so that you get too big to question. Nantucket Nectars did this. Their name technically wasn't trademarkable. They used it as a common law trademark, but they did such a great job back in the 90s with their marketing that everybody knows what a Nantucket Nectar is. You don't have to say it's a fruit flavored iced tea. You know what it is. No one else is going to use the name Nantucket Nectars. Even though it's not a trademarkable name. If you can't get the trademark, then get big fast, GBF. Okay, so these are my key points. You do not have to register a copyright to have one, but you do need proof of publication of some kind. Watch out when creating works based on other people's intellectual property. Always err on the side of getting permission when other people or places get into works you plan to display commercially. If you are creating a brand for a product or service, you must get a federal trademark. Pick a name that's trademarkable, memorable, easy to remember, and where you can get the domain name, especially the .com. When you are using a common law trademark, market the hell out of it to deter copyrights. Hire a lawyer to do a thorough trademark search before you register. Do not attempt to register a trademark yourself without professional help or without using one of the online services, okay? We have a lot of questions here. I know we've only got a few minutes left. I just want to tell to the photographers out there, a lot of people who do stuff on their website like to copy photographs that they see online. You have to be aware of this organization called Getty Images. They're based in California. This is a photo bureau. They own the rights to virtually all historic photographs. So the photograph of the sailor kissing the nurse in Times Square at the end of World War II, we all know that photo. They own the rights to all of those photos. If they see you using one of their photos from one of their database of photographers, they will send you a nasty letter, and they do not back down. They will claim, they will say, and they know, they can say, our records indicate that you've had this photo on your website now for the last 50 days. You owe us royalties of $5,000-$6,000, and they do not back down because they consider themselves a fiduciary for their photographers. They see them as the champions for their photographers. I have never been able to get them to walk away from something. I have sometimes negotiated payment schedules with them, but they do not back down. They will go to court. So if you have a website and you've taken a photo from somewhere else and you're not sure who the copyright owner is, take the photo down, because if it belongs to Getty Images, you will have the fight of your life on your hands. So with that, that's basically all I have to say here. I'm looking through some of the questions here. I have a graphic that represents a business framework. Might it be eligible for copyright or trademark or both? Well, the answer is if you are using the graphic and when you distribute the work or on your website or something like that, it probably would qualify for a trademark. Otherwise, the graphic would almost certainly be copyrightable, even if you don't. The copyright doesn't matter if you're not using it or not. As long as you've created it and it's your original work, your copyright is already attached there. So all you have to do is, put the copyright symbol next to it, and you're okay with that. So that's one question that I can't answer. Budley, I think are we out of time?
Yes, we are. I have enough time to do a wrap up and get everyone out at 1 o'clock. So, first of all, absolutely fabulous, comprehensive. Didn't expect any less from you, quite frankly. So, with that, a reminder and a recording of this webinar that any materials will be available in a couple of days at westernconnecticut.score.org at our website. Can you get to that last slide that we usually put up, please? Please check our website for information on upcoming webinars. That's the one, thank you. And again, SCORE offers free individual counseling, so please use the link on the screen or visit our website and click Request a Mentor. We are available any which way you want to have a meeting with you. Happy to help. Also, please fill out your evaluations that will be sent at the end of the webinar. And on behalf of SCORE, I'd like to thank you all for attending today's live show. And in closing, Cliff, absolutely fabulous.
Well,
Thank you so much for presenting.
it is always a pleasure. If I didn't get around to answering your question, I'm pretty sure I didn't. You can always send me an email, and please feel free to do so. There's my email address right up there for you. It may take me a while to answer your question, but I always devote at least a few minutes every day to answering questions from sport people around the country, and you will get an answer from me eventually. And if I can't answer your question, I'll try to point you to somebody or some kind of an online resource that can. So, Budley, thank you as always for having me. It's always a pleasure to work with sport.
Thank you, Cliff, and have a good day, everyone.